on an ongoing basis. And you will see why. Because it affects us as a country, it affects us as a region, and indeed it affects the world. So without much ado, therefore, I will just proceed with the presentation. And the presentation is structured in 5 brief subheadings. First, because I appreciate that some of my colleagues were telling me, we are very interested in maritime, but we don't know, we are not very familiar with it. So what I have done, I will share with you something brief on maritime zones and their significance. I'll also share then the 1982 UNCLOS adjudicative institutions, just in brief, so that then we are able to place the International Tribunal on the Law of the Sea, which is the one that made this determination that we are discussing today. We will then move on to the background of the case briefly, so that again we understand the context, and then we can discuss the implications, because in these implications, we will then start to ask ourselves, what is the relevance of these particular conversations that we are having today? So the first part, therefore, is to look at the maritime zones. What are they really? So the United Nations Convention on the Law of the Sea is what we maritime lovers and maritime practitioners refer to as our Bible, because it is the one that governs the relationships of the various stakeholders within the maritime space. This Bible that we call the UNCLOS is a 1982 document. It was adopted in 1982, and then upon reaching the necessary number of signatories, it then came into effect in 1994. And it divides the maritime zones, the maritime space, into various zones. So why these zones are important to us is because the zones afford certain rights and obligations to the respective countries. For instance, we have the internal waters, then we have the territorial sea, we have the contiguous zone, and we have the exclusive economic zone. Then below it, we have the continental shelf, and as the name suggests, it's at the bottom of the water. It's now the seabed and the subsoil. And then as we go further still, we have the high seas, and at the bottom of it, we have what we call the area. Now, each one of these zones is demarcated according to a unit of measure that we call the nautical miles. A nautical mile is equivalent to 1,852 meters. So the purpose of today's conversation relates to a dispute with respect to the continental shelf and the exclusive economic zone. This is because a state can extend or can claim up to 200 nautical miles of an exclusive economic zone, and also 200 nautical miles of the continental shelf. But then, depending on the extent of the continental shelf, it can claim up to 350. So if the shelf extends, it can claim up to 350, but there's a procedure for that. And that procedure, you first have to submit that intention to the committee on the limits of, to the Commission on the limits of the continental shelf. So these particular zones, the exclusive, of course, every zone has certain benefits, but the zones in question, the exclusive economic zones and the continental shelf, are particularly usually very rich in resources. And that is why the states enjoy exclusive rights of exploration, exploitation, conservation, and managing of living resources within that particular area. And so even when you look at the dispute between Kenya and Somali, it was also about the same zones, continental shelf and exclusive economic zone. So these areas are very rich areas, and now they are very important because of the issue of jurisdiction, and therefore informs the basis of delimitation, because adjacent states or states that are opposite each other will often claim overlapping rights. You will want to extend your zone of jurisdiction because of the benefits that then attach to that particular area. So because of those disputes, the potential area of overlaps, because of the interest that we have spoken about, what the UNCLOS does is that it then goes ahead and says, as a rule of the thumb, Wherever a dispute occurs, and it usually more or less will often occur with respect to adjacent states or those that are opposite each other, whenever a dispute occurs, the first thing that you're supposed to do is to explore peaceful ways of dispute resolution. You can negotiate, you can do everything that you want, you can go for conciliation, but should you fail, it then provides a mechanism that then has adjudicative institutions. So if you're unable to call each other and agree, if you're unable to agree to share the resources, then you will have to subject that dispute to adjudicative organs, because again, if that dispute is not resolved, then we are going to have chaos. And the thing is that the maritime space is used for many things, including for navigation by other countries. For instance, when Kenya and Somalia are having a dispute, other countries may not be able to access the Indian Ocean. And even is the case with the Maldives and Mauritius, if the dispute gets hostile and it becomes hot, and or when, for instance, in Kenya and Somalia, we had even the cases of piracy, as you know, that could even be used to punish those people who are navigating through those routes. So the need for peace within these particular maritime zones is very important, and that's why then we have adjudicative organs in the event that you're unable to agree. Now, there are four main adjudicative organs, and one of them is the International Tribunal on the Law of the Sea, which is established within our Bible, the UNCLOS that we have spoken about. So it is there, and the mechanism for it is provided. Now, that becomes very important because in this particular dispute, and I have put a map there for us to be able to appreciate, let me just project, you can be able to see where Maldives is. Maldives is right there. Sorry for the predictions there in terms of the theses that are projecting, but I can try and see if I can. Anyway, the subtitles are showing. I did not want that, but I will still project it just so that you're able to see. So Maldives is right there. And then you can see Mauritius is at the bottom of that particular map. So imagine if there was to be a dispute, and then that would mean it could potentially affect this entire area of the Indian Ocean. So in this particular case, you can see where Maldives is, and Mauritius is right here. And that particular dispute arose because initially there was the question of who owns the Chagos archipelago here. And the ICJ, one of the other adjudicative organs, found that it is owned by Mauritius. Maldives, of course, the dispute was mainly between Mauritius and the UK, but also at some point, Maldives said that it also had a right to Chagos Island. But then in the course of it, it dropped that right and or that claim. And I'll tell you the impact of that particular dropping of the claim. But it is important for us to know that Mauritius is an island, the Maldives is an archipelagic state. And the thing about archipelagic state, as you can see there are so many dots. So it's not just one country, it's so many islands then that are able to come together and constitute a state. So you can see that, and then Mauritius, of course, is an island. Now, this becomes important because in June of 2019 is when Mauritius went to court. And if you look at the framework that I shared with you about the adjudicative institutions, then you'll find that where parties have no agreement in terms of where they'll go, where there's a dispute, then the UNCLOS provides a default mechanism, which is arbitration under Annex 7. But then, so Mauritius lodged a complaint, instituted the proceedings under that. But then with time, they were able to agree. And in 2019, a few months later, September, they agreed now to transmit that particular dispute to the ICLOS, which was done. The ICLOS sat from 2019, certain things had been going on. And then in 2022, in 2023, 2023, a few months ago in April, that is when the determination was made. Now, it is important to be able to ask ourselves, what did the decision say? One, as I said, the dispute was with respect to delimitation of the CS, the continental shelf, and the exclusive economic zone. Why? I've told you the various interests that arise with that question of jurisdiction. So Maldives was claiming a certain area. It was extensive, and so Mauritius is the one that instituted the claim, and it wanted more. Already, as you will recall what I said here, already because the court gave Chagos Island to Mauritius, then this area was not what was contested. What was contested was between Chagos and Maldives, now going that way. So that is what the dispute was about, because the maritime zones are established from your baseline. And now, if Chagos has been declared, as you can see, to be within Mauritius, then that effectively means we are starting to compute from Chagos going towards Maldives. We are not going back down. So already Mauritius has that extra space. And you wonder, sometimes even when we're looking at Kenya and Somalia, and Kenya was saying, Somalia already has so much water, why are we, being pushed further? Now you can see the same case with Mauritius and Maldives. And so what the court found in this case is that, one, it actually established the points for delimitation. And what it did, whereas sometimes it can decide a different point with respect to the CS and a different line with respect to the EZ, it established one line. And that one line, in the grand scheme of things, when you look at it, in terms of the measurements that were then given to Mauritius and what was given to Maldives, the disparity was not much. And I'll tell you, when you're looking at the implications, then what that does. The other thing that the court did is that it rejected the objection that was raised by the Maldives to the admissibility of the claim by Mauritius. So Maldives was saying that the court cannot decide with respect to claims beyond 200 nautical miles, because Mauritius wanted to go beyond the 200 nautical miles. And so Maldives was saying, no, the court cannot do that. The tribunal held, yes, we actually can. But in this case, we will not be able to do that. And, like I had said, the Commission on the Limits of the Continental Shelf must also have been approached. Mauritius is supposed to have approached that commission so that then the commission can also make its recommendations, which will then have guided the court when it was, if Mauritius had also submitted that in its application. So again, one of the things, and this becomes important when you're looking at the implications, the court, in finding that it has jurisdiction with respect to the extended extra beyond 200 nautical miles, actually said that the submission by Maldives had not been filed on time. And we'll now see the other problem that arises with respect to that. Now, having seen that the court has awarded, has already delimited this space, having seen that one of the things is that Maldives even had initially said that it has claims over the Chagos Island, and then it has dropped it. And now that affects where we are, the area under dispute, because then we are measuring with respect to the area between Chagos and Maldives, as opposed to the area from Mauritius. So I want us to remember that, so that when we are looking at the implications, which is the next thing, we can see why certain things have been perceived in the way that they have. So the first thing is that, of course, the good thing that comes from the delimitation by the court is that now the extent of nations' maritime boundaries for the two of them, at least up to 200 nautical miles, have now been fully settled. This helps the countries, because then you're able to explore your resources, you're able to get into agreements with countries that want to explore and exploit them at a cost. You're able then to exercise the certain rights that we have spoken about. So that delimitation is important. Of course, the courts the tribunal refused to go beyond the 200 nautical miles. But up to that point, and we have seen the value of the EEZ and the CS, then the two countries are able to enjoy their particular spaces. The other thing, the implication of that particular decision is that when we were talking about the adjudicative organs, the UNCLOS gives them finality. So here, you cannot now start appealing the decision of the International Tribunal on the Law of the Sea. You cannot. It has the final say in terms of that. So that finality in itself, you can see, is also going to affect, or is also going to have a certain implication. And what is that? The political implications, for instance, and we're going to get to them in a minute. The thing that then is becoming very important for us to appreciate is the economic implication of that decision, because then, as I have said, the fact that now a country can be able to explore those resources, exploit those resources, exercise certain rights, including the right of hot pursuit, where there have been infringements within its space. So those are some of the relevant things or the implications then of that particular decision from an economic perspective. But it had even greater political implications. You know, when the decision was being made in April, the elections for Maldives, presidential elections, were coming up in September. And the current president was seeking to be elected. And now it was during his term that the bid against Mauritius for the Chagos Island was dropped. It was also during his term that now this decision that some people are looking at unfavorably has been rendered. And so the decision was condemned, and you know, politicians will always leverage on that and make it look like the president had everything to do with it, and it had a lot to do with his incompetence. So it is highly likely that it affected the election, because despite incumbency, the president was not able to garner 50% of the votes, which the election was held on 9th of September, 20 days ago. So none of them was able to get, and the constitution of the Maldives requires that you get at least 50%, so that then you're the winner. So none of them was declared a winner. And of course, the second round is scheduled for 30th of September. And let's wait and see whether people will continue to capitalize on that particular weakest link for the president. Then the other thing is that, of course, it generated a lot of dissatisfaction locally. And perhaps this may have also impacted on the political implications that we have just discussed. The other very critical issue for not just Mauritius and Maldives, but for us as Kenya and other countries within the Indian Ocean Rim, and perhaps even globally, maritime nations, there's a question that comes to mind. Because the 70% of the world is water, and many of the countries are yet to delimit their maritime, to delimit their maritime spaces. It therefore means that there's a potential for very many cases. And we have seen that the decisions are often causing adverse impact, both domestically as well as internationally. This therefore means that there is perhaps a need for us to examine whether this framework for dispute resolution, the issue of having adjudicative bodies, as opposed to perhaps laying more emphasis on other forms of dispute resolution, is a good thing. The thing is, again, even as we're looking at the question of efficacy, if we were to say, okay, let's not adjudicate, let's go to conciliation, will it not have the same impact, especially where a president may be deemed to be a sellout? You see, we have seen, for instance, where we had the dispute between Kenya and Somalia. After the decision, the president said, we are not going to yield even an inch. And it is the same thing that has happened. In fact, people in Maldives are saying they want to impeach the president. So given the hot arena, the hot tensions this topic generates, is it ever possible for people to actually agree? What is notable is that there are countries, including Seychelles and Mauritius, that have gotten into what we call joint development and cooperation agreements, so that it's not a win-lose, but it's a win-win for everybody. Is that the best way forward? Perhaps we need to start thinking of other alternatives, and alternatives that can actually be less likely to cause too much friction. So with that said, it is important, therefore, given the impact, to consider other viable alternatives. Otherwise, especially given the adverse ramifications for a country then that deems or is deemed to have lost, then it may get to that point where we may go back to very hot disputes. I will rest it at this point and allow any comments, and actually take it back to the moderator, so that we are also comments from the discussant, and perhaps take questions as well. And we hope as we go along, we will continue to find benefits. Thank you very much.
Thank you very much, Wakili. Again, a round of applause, although maybe you may not be able to see the applause, but they can be done virtually. Yeah, the presentation was very elaborate and informative, and noting specifics that I've gone to in terms of delimitation of maritime boundaries, and of course, basing the discussion of the judgment of the special chamber. Now, I've also noted a few things. I believe the delegates have also been noting down for the question and answer session that will come later. You discussed the origin of the dispute and the significance of the disputes, including its impact on free navigation on the international waters. I also heard something about the common heritage of mankind, whereby the ocean floor resources and the subsoil are beyond the national jurisdiction, are supposed to be used by all. Then also I heard about timely submission, the importance of timely submission to the ITLOS in case other alternatives are not feasible. And the presentation also highlighted maritime zones, the rights and obligations that fall under each zone. And more importantly, I can say that the presentation suggests alternatives to adjudication, which should actually, I think this is what our delegates today, the persons who are present in this webinar, should be looking into, which of course saves the country a lot of pain, especially in terms of the freedoms that can be limited during the dispute. Also effects like the political implications, as well as other economic implications. So I'll rest it at that. And before we go to the questions session, I would like to introduce our discussant, Komodo Srikant Kesno, who will be joining us shortly. He's an alumnus of the prestigious National Defense Academy, and he was commissioned in 1986 in the Indian Navy. He has a 36-year career, which is very extensive in experience in maritime operations, training, professional military, and leadership and diplomacy, among others. Captain has been a captain of frontline ships in his tours of duty. He has witnessed several important assignments and prestigious courses and interesting tenures at sea and ashore. He has a PhD from Mumbai University, apart from other 5 postgraduate degrees in science and social sciences. He's also an author and a lead writer of not less than 12 books and monographs, and many, many journals for the Indian Navy. Captain has been involved, Commander has been involved in several academic and creative corporate outreach endeavors of the Navy. He is now retired, but prior to his retirement, he was the director of the Maritime Warfare Center in Mumbai, and in addition, also officer in charge of the Naval History Project. Commander was conferred the Vishnit, I don't know if I said it right, Silver Medal, VSM. He will correct when he comes in to take up the short session, in Presidential Awards in 2021 for distinguished services of high order. So we are very privileged to have Commando Srikant Kesno in this webinar. And I would like to say before I conclude his introduction, since Commando's retirement, he dedicates his time to the cause of spreading maritime awareness through teaching, writing, and public lectures, such as we have today. And now I would like to invite Commando Kesno to make a few remarks and highlight on the presentation that has been presented by Wakili. And without much ado, Commando, if you have a presentation, you can upload it or you can speak. It is up to you. Karibu sana. We say that in Kenya, karibu in Swahili. You're most welcome.
Thank you, Madam. Thank you, Madam Josephine Asante. And one of the things in my career that I'm extremely happy, proud, and what I would rate as the finest memory of my 36 years career was the 3.5 years that I spent in your beautiful country, in Kenya, in Nairobi, as the defense attaché, defense advisor for my high commissioner, and my area of responsibilities included East Africa and as also Eritrea and Somalia. So, and that was during the peak of piracy between 2008 to 12. So many of the things that you say or what Advocate Joki said has lots of salience for me. Thank you for giving me this opportunity. It's wonderful to be with you, wonderful to be with a set of professionals. And I would begin by saying that it is great to have an association of maritime professionals, because let me begin by complimenting Kenya. That we need to have bodies like this, because we sometimes tend to forget, as Advocate Joki has said, that 70% of our world is covered by waters. So unless we have a maritime outlook to our lives, we would miss out on many of the opportunities, and we might ignore many of the threats that come from sea or arise in the oceans. So I think the need for a maritime outlook is paramount amongst countries in this region, particularly now that we are all realizing the importance of what may be called the blue economy, when we tap to the seas to get greater wealth, to use oceans and seas for sustainable development. So to that extent, it's wonderful to be with you and wonderful to be with the Association of Maritime Professionals. I think I will begin by complimenting Advocate Joki. She did a wonderfully succinct presentation. She brought out the highlights of this recent judgment. She began very well by illustrating sometimes the maritime zones become an alphabet soup. They become confusing to people on land. And just as the best of Air Force pilots find it difficult to fly over the sea, the best of lawyers who deal with cases on land find it often difficult to understand waters in the maritime domain. So I think she was very good at bringing out what are these maritime zones and what do they mean, and how does the extent of nation's sovereignty differ between the territorial seas and then the EEZ and the inland water, the EEZ, and going on to what's the continental shelf. There is something called contiguous zones also in between, which gives a bit more rights than the territorial seas. And these are some of the issues that have ever since UNCLOS was unveiled in 1982, befuddled, engaged lots of maritime scholars, lots of people, lots of lawyers. I speak to you not as a legal expert. That is the lady on our show who made the presentation. She's the lawyer. She's the expert. I speak to you as someone who has been in the maritime domain, who has interacted with academics, and who has dealt with certain parts of operations and think tank activities in a manner of speaking. So I think the important things that I could get out of this was where she talked of the issues of delimitation. What happens when countries have overlapping areas of interest? I think that is the point. If you have clear seas that are your EEZ or continental shelf, probably then your worry is not about what is your area. Your worry is about whether you have a different order of worry. If you know what is your EEZ, you will then worry about if whether somebody is intruding, somebody is doing illegal fishing, somebody is poaching on your resources. But what happens when within what UNCLOS says two countries have overlapping claims? And how do they then reconcile those claims with regard to the UNCLOS? I think that was brought out uh, very well by Advocate Nyoki, because I think she mentioned some of the key areas there. That if countries have a dispute, then that dispute sometimes spills over into other areas. And she mentioned piracy. She mentioned that the precedence of one issue could have, consequences to other cases, and trying to see whether this would have an impact, for example, on the dispute that Kenya is having with Somalia. But more to the point, that countries would have disputes, and how do you sort of settle them when the jurisdiction is with an international tribunal and the judgment, so to say, is final. I think she made a very, very important point about submission of claims in time, and these are key, ladies and gentlemen, because the UN gives a lot of time, but these are technical issues. I think the judgment was very, very nuanced. It said, look, we have jurisdiction to adjudicate between the continental shelf of Mauritius and Maldives, but we still don't know what is the extent of this continental shelf, which has to be determined by the separate technical body for that. And I think that's a very important distinction she made, and we must understand that, because these are technical issues, which are overseen by domain experts. It is necessary for countries to do that in time. Now, how does, and this is where I come in, how does a country give its claims in time? It gives its claims in time if it builds the requisite maritime knowledge and professionals in the country. After all, you can wage a claim to a certain real estate of the sea. A, if you understand and appreciate the sea. B, if you understand its importance. C, if you have legally minded people who can fight the cases, interpret the law. D, most importantly, if you have updated, surveyed maps, what we call as charts in the nautical language, you need to first have updated, well surveyed sea areas to know, look, what is mine and on what basis do I make my claims. Therefore, it's necessary for countries in the region to grow organic capabilities in a range of maritime disciplines and professionals, maritime law being one of them. But hydrography, for example, ocean hydrography is a very important thing. All your claims will start from the point that you know where my real estate begins and ends. So I think she also stressed in a very finely nuanced way that what happens, what is the best way to settle disputes? Is this the way, prolonging it? And in this case, there were special circumstances because of the issue of Chagos Archipelago, about the fact that Chagos is far away from what can be called in some way island Mauritius, and that brought it in its own complications or complexities, if you can say so. And what happens if countries have disputes, and not everyone can or should go to war over these disputes. So I think she's looking for the audience interaction to give some answers. So I will just add to that to say that, look, in many of these awards, like in the Mauritius Maldives Award, the ocean area given to both countries is nearly the same. As I remember, right, there's probably a couple of thousand square kilometers difference between the two countries. So sometimes people might say or suggest that it is better to accept what award is given and start using that area better. Start fishing, start using it this one, police your areas better, rather than keeping on fighting legally without knowing how long. That is one point of view. The other point of view, of course, says that you must have a long-term view. I think Advocate Joki also brought out very well, and one of the biggest problems in these disputes is political issues back home. When you are in democracies, and many countries have a stake in having democracies now, and they are in fledgling states of development, you want that to get more better, more participative. But when you have participative, noisy, vibrant democracies, one of the things that happens is that uh, many people challenge. They feel that the party in power has not done enough to press its claim. So it unleashes feelings of nationalism, it unleashes various political currents. The opposition party, the media, all of them then try to bring in and say that we could have handled this better. So that places certain pressure on the country to be able to accept or not accept, or how much accept. This is a very important point, and one doesn't know how these can be resolved. In the end, I would just like to quote, from India or of India, a couple of examples which might help, give some directions. One is that India and Bangladesh had similarly gone to the Permanent Court of Arbitration, and in 2014, the court ruled, and the ruling was very much largely in favor of Bangladesh, but India accepted that, and I think accepted that in a very proper manner, with our foreign minister saying that, look, we accept, it is binding, and we may be disappointed by the outcome, but we accept it. And I think that in some ways, we all know that there are countries that don't easily accept such rulings, or resist this, even though they are signatories to the UNCLOS. So the fact that India accepted it without demur, I think, um, showed some sort of a welcome way ahead, because as a big country, as a country having its own interests, I think in some way, even though people within may have criticized and felt that we should not acquiesce, I think India on the whole set a wonderful example. The other two relate to technical domains. In recent times, India has developed huge expertise in what I called as hydrography. We've got some of the best ocean mapping resources in the world through our ships. India has been helping countries in the region help map them. And it's not for me as a retired officer to suggest that countries in this region must seek or partner with India, but just to suggest that, look, uh, only collaboration can work in such areas. The ocean areas are too vast. Even the American Navy talks of 1,000-ship Navy. So ocean areas are too vast, and collaboration can help. And India has built lots of excellent capabilities in hydrography. The other area we have built excellent capabilities in is information about what happens at sea. It's called the white shipping information, because the sea is full of good and bad characters. To know who are the bad characters, you must know who and where are the good characters. And that's largely called white shipping information. We have a fusion center in Gurugram, close to our national capital, that is represented by, that has representatives of many countries. I believe countries of East Africa are also there. I don't have the exact figures, but they would be there. Recently, they had a conference which had more than 30 countries included, including all countries in the Indian Ocean Rim. So that is the way ahead. Some part of answer to Joki is the way ahead is to be more informed, because often we fight from a point of ignorance. The way ahead is to be more informed about what happens at sea, and to do that in a collaborative way, because that is only the way ahead. In the Navy, we often say that those who rule the waves often waive the rules, but in order that those who rule the waves don't waive the rules, I think the Committee of Nations should build collective capabilities to prevent some person from saying, "I'm the Lord and Master of the oceans." So I think I'll leave you with those thoughts, and I could take any other observations that come. But I must compliment you on a very wonderful presentation that put forth the issues and implications very, very succinctly. Thank you very much.
Sure. Thank you very much, Commando. Actually, I was getting carried away with the discussion, which you have actually summarized very, very well. We note your comments on developing professionals who are able to assist a country, for example, Kenya, to amicably resolve a dispute before it gets to adjudication. We also note the importance of having not only legal professionals, but as well technical professionals such as a hydrographer to support a country, for example, in designation of sea areas among other areas. So thank you very much. And I see time is moving, and I know our participants are eager to ask their questions. So this is the opportunity or the space that we would like our participants to react on the presentations that have been given by way of questions, comments, or even recommendation on areas that Advocate Njoki can improve on his PhD work. The two discussants will be responding to the question, and I propose that we ask our questions in a way that you identify yourself, for example, your name and your institution or your profession. And for the students, you can identify yourself by the way of name and also the institution that you come from. The questions are welcome. Thank you. You can use a virtual hand raise on your screen so that we can see you. I can read a comment from Samuel Mumbura. Kenyan, I think it's Kenya National Examination Council. Samuel says, thank you, Advocate, for the insights shared following that ruling and that forms extreme areas of jurisprudence. Can the presentation be shared? I think that is what Samuel wanted to ask. And Samuel also asked you to comment on the issue of sea rises on existing maritime boundaries. Either of you can answer, can respond, Advocate or Commander.
Would you like to go first? I think you should.
I can. Thank you very much. Thank you very much, Samuel, for that question. In fact, it should have formed one of the things that we indicated at the very beginning, because again, one of the implications of the decision, it causes us to ask ourselves. Remember, we said that maritime zones are measured from a baseline, and there is a method for determination of the baseline. And bottom line is that you use the water tide, the water mark. So the thing is that with climate change, then the water levels continue, the sea levels continue to rise, which then in effect affects the low water mark, all right? And so if the low water mark is affected, it effectively moves or adjusts and comes inward because the sea level is rising inward. But then you see, nobody then goes ahead to readjust the maritime zones. So in fact, one of the recommendations that has been made is that should we have fixed uh, baselines, is there a way that then we can go about remedying the fact that the changing sea levels as a result of climate change could then potentially affect the maritime zones and eat into your space inward? I don't know whether that helps, and Commodore, please feel free to add. You know, sometimes when you talk too much, you're unable to listen to yourself.
No, I think I agree with you to a large extent. The question is interesting because it actually happens, like you brought out, not just change the baseline. What happens if your claim is based on one island and that island suddenly sinks? Then does your EEZ change? Does your shelf change? Everything like that change? Because the baseline adjustment due to rising seas, you can still. What if you have a small little island, remote island? And again, interestingly, I think you can Google on something called the New Moor Island. This was something that India and Bangladesh in the 80s had a bit of, conflicting claims on that. And now the island is no longer there. So in some ways the conflict is buried, and of course, consequent to the 2014 judgment, both the countries have moved ahead. But this can indeed create scope for huge amount of differing perceptions because rising sea levels are certainly a concern. And that is where, in some ways, look, I'm not educating or advocating for anyone, but island nations, and particularly archipelago nations like Maldives had made this concern about rising sea levels known in various ways, including once having a parliament session underwater to sort of focus on what are the problems that people on small islands with rising sea levels may face in future. So in some ways, the worry of people in such places has to be seen and understood in the context of rising sea levels. I think you make an excellent suggestion there that, look, can we freeze these? That once we agree to a certain delimited border, we say that this will not change irrespective of any changes in the baseline or any changes caused due to global warming or something like that. Once we delimit and put flag on it, so to say, we must not. But that's easier said than done. What happens? The animals in the sea, the resources in the sea, they are not bound by ITOS or UNCLOS. You can't ask the tuna. You can't ask the tuna not to migrate. From one EEZ to another. So what happens if the other area has more tuna, more fish, more resources? Now you'll say I must lay a claim on that. So these are not easy questions, but easy to answer. But I'll go along with your suggestion that try and freeze it at a particular time and try and get bipartisan consensus on that issue.
Right. Thank you. I believe the questions are answered. If they are not, kindly let us know. I would also like to read the question submitted by Rafael Olieti. Rafael asks, what are the enforcement mechanisms available to ITLOS? And second part of the question, how does it ensure compliance with its orders? And I would like Commando to go first on this one.
Thank you so much. The short answer is nothing. Unfortunately, and this is one of the problems that global mechanisms have, that while they can give a ruling and it is final and it is supposed to be binding, there is no way that they can enforce it. which means that it entirely depends on the outlook of that country, whether to accept or not. You can create certain moral and diplomatic pressures. You can bring in other friends to try and do it, but nobody can force. You do not. You do not even have an international maritime equivalent of a peacekeeping force that you have on land sometimes to go and there too it's consensual, but at least you have peacekeeping forces in land. At seas, this is difficult. And please understand, sir, uh, I will now give a historical perspective to this. Uh, the seas are the original global commons, the way internet is today. And anything that is a global common hates regulation. So unlike aviation, which is very, very strongly regulated, maritime domain is not very well regulated. More importantly, it hates regulation, which is why you have all these. And the areas beyond national jurisdiction is actually more than 50% or nearly 50% of the world. So while there have been attempts to regulate this through a variety of mechanisms amongst the countries, it's not easy. So the idea that you can have a global policing force to enforce some of these uh, is very unlikely. Where the global concert of nations operates, where it operates together, is when you have situations that happen in choke points or key areas. The reason the world took notice of Somali piracy was, sorry, my mistake. Not Somali piracy, but piracy in the Gulf of Aden. The reason the world took notice of that is because it was happening in a busy international highway, you know, and it was threatening global traffic. So, if there are some cases like that, you might have a concert of nations operating. If it is not, if it is a bilateral dispute between two members and one refuses to go, and there are precedents in international system of countries that don't obey courts, you can Google and find out which these countries are. Unfortunately, you can't have anything to make them, sort of enforce it.
Thank you, Commander. Advocate Njoki, would you like to add to Commander's comments?
Well, just that, and I completely agree with him, and that is one of the problems that then we face, because we are relying on state parties' goodwill in terms of implementation. The worst case scenario is and I think now, where if now it's an extremely hot case, yes, you can ask for the intervention of the UN, but now for the UN to intervene, as the Commodore has indicated, it would have to be a matter where, even the states with veto have a stake or some skin in the game, or a matter that has such huge global implications that then would call for people to intervene. So that in itself, given how heavy it will be to lift that particular machinery, it is as if to say there is none, as Commodore has indicated.
Okay. Thank you very much. I believe, Raphael, you've been answered. I'll read also the comments for Onesmus Mwao. He says, thank you very much for such an informative presentation. He's now enlightened on marine zones and that there is a process of settling a maritime dispute. So somebody has learned something today. And Kathil Dev Barrow says, this is an excellent presentation. Right, I'm continuing to read more. And then Jero Nicolas says, a great presentation. And the question he wants to pose to the team: does UNCLOS apply to maritime boundaries dispute resolutions on the inland waters, such as the case of Migingo Island in Kenya? And that is in Lake Victoria. I think, Njoki, you can answer that.
Thank you very much. In fact, I wanted to make a joke out of it. Said he has, gotten the words right off my mouth. You see, the UNCLOS gives a definition of what an island is, and in one of the slides there, when I was talking about Mauritius and saying that it's an island, so there's a criteria. Is it just a rock, or is it a rock that can actually, or is it land that can actually sustain life? And that is why, so if it checks that criteria of what an island is under the UNCLOS, then it would constitute an island. But if it falls short of that particular requirement, no matter, and you know what, the UNCLOS even further says that in as far as the procedure for delimiting maritime zones is concerned, you cannot use artificial islands also, not even if supposing you could, as China has done, supposing you could establish an artificial island and put humans and make it such that can sustain human life, you cannot still use artificial islands to measure the EEZ, or to measure the maritime zones as if it was the natural prolongation of the land. So those two things are very important. The criteria for islands, so that then it can now be able to be the point from which the maritime zones are established. And then number two, the fact that artificial islands, even if they were to check that criteria for islands, will still not be the basis for establishment of maritime zones. I don't know if that responds to the questions. Commodore can also supplement.
Just before we go to Commodore, sorry, Commodore, I'll hold on a little bit. I would like you to conclude. So I'll invite the head of Secretariat to make a comment before we go to the international territory of India. Thank you. Head of Secretariat, you're welcome to make your comment, please.
Thank you. One, of course, I want to acknowledge the presence. I didn't know Captain Kapil Dev Behel is here. For my Kenyan friends and others, I must inform you that he's a very distinguished master mariner and a merchant navy captain of many years of great experience. He also heads several maritime bodies in India. He's recently written a book on one of the earliest maritime institutions in India called the Dufferin, which was a training ship or academy for merchant navy training people. So his presence is a real honor for us. Advocate Joki, I think what the question didn't relate to island. I think he was talking of inland waters. I think he made a reference to Migingo in Lake Victoria. So as far as I know, I don't think this jurisdiction extends to inland waters, but perhaps you can highlight more on that. But one of the interesting things, and this is a sideways, a bit of tangential reference, but important for all of us, to suggest that even landlocked nations and sort of inland nations what happens at sea has implications for them, whether it is trade, whether it is blue economy, whether it is things coming. So landlocked nations also must take interest in what happens at sea. And I think I just saw some reference to Ethiopia having a conference on Red Sea security. And I think these are very, important indications about how countries that don't necessarily have a sea border are also interested in the sea. And that is what I wanted to say. But I don't think inland waters, there is jurisdiction, but you can probably answer that.
Thank you. Would advocate want to go in, because there is someone who is requesting for the mic before we give them, or we would like to come in after them?
Any point you want to give me the mic, I'll take it.
All right, let us give to one of our participants, Engineer Kagimbi, who would like to make an intervention on that note. Karibu, Engineer. Kindly unmute.
Challenges, but I'm back. I would like to thank AMK, the organizers of this webinar. It's very, very informative and very good. And the speakers, especially, I'd like to thank Dr. insight on the law of the sea. It's quite interesting, especially maritime zones. I was just interested in the treating for organs because, as she said, ICJ is one of them. And then was ICLOS. And I was wondering, for example, in the case of Kenya, when we had that dispute, everyone knew that the president of the court from 2018 to 2021 was a Somali national, Abdulkarim Ahmed Yusuf, and Kenya tried to remove the case from ICJ, but of course it did not succeed. So I was just wondering whether had it been taken to ICLOS to have a different outcome from what we got, because I think definitely you cannot rule out that Kenya did not have a fair chance in that case, having the president of the court coming from one of the interested parties. So it's very, very unfortunate that this case in free judgment cannot be appealed at all. Kenya had a point of appealing because definitely it was not fair. Maybe you can make a comment on that. Thank you.
Thank you, Engineer. I believe the discussants have heard you. Engineer's question, if I heard him right, he's requesting to know if there would have been a different outcome if not the president of ICJ was of a Somali descent. If our case had been taken to ICLOS, that is the Kenya-Somalia boundary delimitation clause.
There's some background noise.
We'll request engineer to mute. I think that is coming from.
Can he be asked to shut his mic or something, because there's a continuous scatter?
Excellent.
Yeah.
Thank you. So is a question whether the decision would have been different if it had gone to the ICJ, to the ICLOS, because the Kenya-Somalia one was determined by the ICJ. So I'll respond in a couple of ways, and then Commodore feel free to supplement. Number one, even with respect to constitution of panels, the countries usually have a say, the disputing parties usually have a say in terms of having somebody from within your jurisdiction, both with respect to the ICLOS as well as with respect to the ICJ. The other issue is that, for instance, when the ICJ was making its determination, it applied the equidistance principle, and Kenya was making a case for the parallel of latitude, the latitudes, and as opposed to the equidistance principle. So the court used the equidistance principle, and interestingly, it is the same principle that the ICJ, that the ICLOS has applied in this case between Mauritius and Maldives. So over time, it would seem that the jurisprudence that seems to be developing, even though I strongly find inconsistencies, now from the 2022 decision, 2021 October decision with respect to Kenya and Somalia, and with respect to the decision of April 2023 for Maldives and Mauritius, the courts seem to have adopted that, what we are calling the three-stage process. They're saying we're going to use equidistance, and then we make the necessary adjustments if necessary, so long as those adjustments then will make sense and they'll not be overtly prejudicial. So I would say even for Kenya, there is a question of when we raised our objection with respect to the constitution of that particular bench. We did quite a lot of things. We were involved in quite a lot of things. And then towards the end is when, and this person had been there for quite a while. So of course, given that the person is a president, there is, again, when we are looking at the issue of law, we say the issue of apparent bias and things such as that. But there are internal ways, including those ones of empaneling, or the party being able to have an extra person from a certain area join that particular bench that countries can take advantage of. So it's also a question of, even though that concern was there, whether we as a country were able to take advantage of the opportunities that we had to then try and cure that particular gap that we felt potentially could exist. Thank you.
Thank you, Akili. Looks like Komodo has something to say. Is it on the same question or another question?
Yes, ma'am, a little bit. Though my answer largely depends on how Advocate Joki, interpreted the question, because I frankly didn't hear much of it. There was far too much of static. So I'm going by what she understood the question to be. And I think the answer, and I'm not giving a very legal answer at all because I'm not a legal expert. But I would think that two or three things will come to mind. One is that a country ought to go to the mechanism that believes it has the best chance of winning. It's simple. It is every country's right to get the best for its citizens, for its people. So if you feel you can get a better deal in ICJ, go there. If you feel you can get a better deal in ITOS or other tribunal, go there. You got to sort of know where you might have better chances of winning, and that could be based on numerous factors. Broadly speaking, though, I would think that specific tribunals take a more technical specialist view, whereas the bigger, broader courts perhaps consider various other issues that might impinge on this. And this is not to suggest that one is better than the other. This is just to suggest that between special courts and normal courts, there would always be difference in the way they interpret things. And you must sort of bet on where you think you got better chances and go there. Specific though, I mean, again, I'm not getting into the Kenya Somalia issue at all. It is not at all my brief one way or the other to say anything on this. But I do remember an article written, I think in 2019, I don't remember the gentleman's name, where he had actually written that either way there will be two losers, that irrespective of how the court rules in whose favor, given the huge amount of bilateral relations and the commonalities and other interests that bind Kenya and Somalia, having this dispute is not good, and somehow the two countries must come to an agreement with each other. Otherwise, either way, it might sort of bring forth other issues that are not necessarily for the good of our countries. And I think that is the point that I missed the previous question made by by Captain Bell, where he's asked if countries in the Indian Ocean realm have settled maritime disputes without going to any of the courts. I'm sorry, sir, I don't have any details offhand, but it would suggest to me logically that I think the advocate flashed that so far 36 cases have gone to the tribunal. So I would guess that many others have been settled bilaterally. And normally that's a very good way. Each one of us may have differences of opinion about what constitutes our maritime zones. But if two countries in a spirit of friendship and cooperation decide to sit together and do it, it might work to the benefit of both. And then you get to the business of actually starting to police your seas, guard your seas better, and ensure that your treasure chest, so to say, is secure, rather than probably keeping on fighting in courts, at the end of which, if the opposing parties don't agree to go by that, you have no way to enforce it, you know. And of course, the question is that irrespective whether you want to go to ICJ or ITOS, I think as Advocate Joki brought out, both parties agree to that redressal mechanism. It's only then it can go. And at every stage, you can raise objections and your objections will be considered. So to a large extent, I think procedurally, at least, either both of them seem pretty much as good as each other, you know.
Fair enough. I think the question has been given justice. Probably we'll go, we still have some time. There's a question from Clinton Owino, and it is a follow-up on the jurisdiction in inland waters. And he says, I am really impressed with such a kind of presentation. It's wow, attached to a question asked by a colleague. Does UNCLOS 1982, or rather the maritime law, apply to inland waters bordering more than 1 or 2 countries, as in the case of Kenya, Uganda, caused by the fishing activity? I would like to go first. Advocate Njoki, I think just go first, then we go back to Kanmodo. Thank you.
All right. Thank you very much. So by and large, it covers, the UNCLOS covers the maritime zones. The internal waters are not, the internal waters are not within the broader scheme of the UNCLOS. That's the short and long of it.
Yes,
Yeah,
completely. Yes, I agree with her. And do remember what is the last word in that United
Sea.
Nations Convention for all of the
On
sea.
the
So it is clearly about sea. And there is a huge danger when you sort of take it to inland waters, because inland waters are not merely lakes, they could be rivers, and rivers connect countries. Then you directly get into issues where people live, connectivity, and that is a huge minefield, you know. So those are dealt with more at the national boundary issues. So I don't think the UNCLOS has any sort of while it defines certain inland waters, and those are inland waters which are an extension of the sea inside, you know. But I don't think it has any jurisdiction over disputes on inland waters such as lakes and all that under the UNCLOS.
Perhaps, thanks, and I agree on that, and I agree with that. Perhaps just to add that the other interface where we usually find between the inland waters and the UNCLOS is when we are talking about intermodal transport. You know, so that yes, the cargo will eventually, either if it's going outside through the sea, it will come, and that will be an interface from the the inland transport, if the inland transport system includes the lakes and all that. But that is the main point of interception.
Thank you for highlighting the main area of convergence between the inland waters and jurisdiction and the UNCLOS jurisdiction in terms of the seas and its jurisdictions. Now, I do not see any other. Wow, there is a question that has popped up. Thank you. Joel Kimtai, he says Mauritius plans on imposing an area to avoid for vessels which are 12 nautical miles off its shoreline in response to an oil spill relating to Acacia under the National Contingency Plan. He is asking our panelists' view on this in relation to Kenyan waters. And again, I think Advocate go first, then we'll conclude with Commander. Thank you.
All right. Thank you very much for that question. And thank you, Josephine, as well. Remember on our third slide when we were talking about territorial sea, which goes up to 12 nautical miles. And the treatment, you remember why we said the implication is because of the rights and obligations that attach to a state within those specific zones. 12 nautical miles, that's the territorial sea of that country, and it is treated as if it is the land. It is the rights and obligations of a country within its territorial sea. The sovereignty extends. So whatever is done on land, whatever authorities and jurisdictions you have on land is the same within the territorial sea. And it not only stops on the waters, but also extends to the airspace and the water column as well. So if it's within 12 nautical miles, then by all means, it has the right to do that. If it's within 24 nautical miles, that the rights are those ones of enforcement with respect to infringement of sanitary and phytosanitary requirements. Yeah, so the 24 nautical miles, that's an enforcement zone. So you don't have absolute, sovereignty. But if it's within 12 nautical miles, it can do what it wants. The only thing that it cannot limit is the right of innocent passage. And the UNCLOS also defines what the right of
Wanda, your
innocent
take on that
passage
one?
is.
Yeah.
Josephine, did you hear the part about the right of innocent passage? So it can't limit, even if it has sovereignty within 12 nautical miles, it can't limit the right of innocent passage.
I'll just again go along with what she said. I think the question, of course, needs to be seen from, I mean, what is your opinion on what Kenya should do? That's none of my business to answer. I think there are more eminent people sitting there. But I think she flagged the issue that 12 nautical miles is the country's territorial waters, and the country has rights to this one. But innocent passage often, becomes a loaded question in itself. What becomes innocent? Does going up and down, you are moving continuously, but you're going up and down in the same waters. Does it become, it is uninterrupted, but does it become innocent passage? Mauritius's response is in response to the Wakashiko oil spill. And for island nations, things like oil spill, for any nation, for example, that takes away a lot of your marine life and marine resources due to pollution caused by the spill, is, I think, hugely dangerous. So if a country wants to limit, the rights of ships to pass close to its waters, 12 nautical miles, it probably has a case. Now, whether that case will get transferred to being seen as interfering with innocent passage, I think will have to be examined by legal experts based on what is the exact nature of Mauritius's notification. I don't have access to this. We don't know. And we must defer to experts who might have the full text in case Mauritius is planning. And whether Kenya should do that, I think that's a hypothetical question, because it has to be played out legally to see. It has to stand the test of legal scrutiny. And then, of course, also remember that once you lay, as we say in the Navy, that there is no point making a regulation that you cannot implement or enforce. A country should be able to do ABC only if it is able to then take action against people who break that law or who don't follow that regulation. Otherwise, anything that you sort of proclaim will be seen to be very flaccid and may not have the kind of standing it should have. So I think any country that is planning anything here within the ambit of UNCLOS, but with whatever interpretation it wants, first it must stand legal scrutiny. Second, it must be capable of enforcement.
Thank you, Captain. Thank you, Advocate Njoki, and thank you all the presenters. I think we have had a very, very, very fruitful deliberation. A lot of feedback is coming in from the participants, and I believe we should come back again and address other areas that have come up during the conversation. I am seeing a lot of interest on inland waters, navigation of inland waters. I've seen a lot of interest in the rights of innocent passage. That is a whole topic that can form of this discussion, the 2-hour discussion. So we've received the feedback from our participants. And noting that it is Friday, and by the way, Commander, on Friday in Kenya, we take a holiday. The weekend starts early. So I would like to hand over back to Captain. And before I do that, I would like to wish all of us a very, very happy World Maritime Day. I'd like to celebrate the World Maritime Day in style today, this weekend, now that it has fallen on a Friday. I hand over back to Kenya Secretariat for the other part of the discussions. Thank you very much.
Madam, before you hand over, may I express my thanks. You must always have the organizers and moderator have the
Thank
last
you.
word. So before that, I would like to sort of express my complete sort of thanks to organizers, to the Association of Maritime Professionals, and to all of you who made it possible. You know, my PhD thesis was on how India and East Africa can have better relations through maritime diplomacy. So this is very close to my heart. And thank you for giving me this opportunity to spend some time with you virtually online. And I'd just like to end by wishing Advocate Njoki the best in her endeavor to become the President of Law Society of Kenya. I wish her all the best and hope that that becomes a fruitful innings too. Thank you very much, Asante. And it's a big weekend here also. We used to be told that you must never disturb anyone on weekend because everyone goes up country. And up country, there is no jurisdiction of unclause, right?
So we really, really appreciate your presence too, noting that
Thank
it's a
you.
Friday for you too. Thank you very much. Advocate Njoki, before I hand over to the Secretariat, do you have something to say?
Thank you very much to our association for making this happen. It is our duty that we take very seriously. Sorry, I disappeared. It's a duty that we take very seriously as a country, as a region, and as a people. So it's very important to us that we do this and that we continue with these kinds of engagements. To thank Commodore, because again, as you have said, one of the critical ways that India and Kenya has agreed on as a way of diplomacy is the people-to-people contact, and this is indeed one of those ways. Maritime disputes are matters that are cross-cutting to the world, and so it is the business for all of us. To thank Josephine, you have moderated the session very well. You are our champion for today. And to thank our participants also. You are our World Maritime Champions for your participation. And to thank Commodore, indeed, I hope next time we are having a session like this, I will be the president of the Law Society of Kenya. Thank you very much. Back to you, Secretariat.
Yes, thank you all. I invite Captain Salim. Officially, I'm handing over the mantle for the evening. Kindly take over the mantle and conclude the session. Thank you.
Thank you very much, Josephine. And I don't need to say that, to repeat again that it was a job wonderfully done. Before, I would like to reintroduce you again because maybe some people did not get to know you better, Josephine. I would like to acknowledge the presence of the chairperson of WOMESA, Madam Fiona Mbadi. And I would also like to thank Chief Engineer Wilfred Kagimbi for that short word that he participated with. And I would also like to thank all our overseas participants, Arun Visvanathan, and I think Kirti Tehas, Kapil Dev Bal. Thank you very much for joining us in Kenya for this wonderful discussion that has been effectively handled by Advocate Harriet Njoki and Commodore Dr. Srikant. And it is important to highlight the achievement of the moderator who has held down, the way we say it in Kenya. She has held this session wonderfully. And it is important that we highlight that her interest in international maritime legislation took her back for a second master's degree in another IMO institution, the International Maritime Law Institute, where she graduated with her Masters of Humanities. And the dissertation, I would say, was a wonderful dissertation. I have read it myself, and I would urge participants also to look for that dissertation for our moderator from the International Maritime Law Institute in Malta, and also to read it. And I would also wish to commend her for her work, which we did under the Maritime Education and Training TC, which was a special committee on the establishment of the Kenya Merchant Navy Training Board, where her experience as an IMO-approved IMSAS auditor was key, and also her experience as the single point of contact for the IMO member state audit scheme, which is the IMSAS, and in addition to her critical role that she played during delivering Kenya's enrollment back into the IMO STCW whitelist in 2010. I would wish to take this opportunity on behalf of the president of the association, Captain Suleiman Bakari, to thank in person Commodore Dr. Srikant for making the time available to join us in Kenya and to discuss matters of mutual interest, and also to thank in person Advocate Harriet Njoki, who is the chairperson of the Technical Committee on Maritime Law and Policy of the Association of. Also to thank in person our wonderful moderator, who is an associate member, and also Njoki is an associate member of the Association of Maritime Practitioners, and also all the participants who have joined us to discuss such an important topic today, where we have seen we have had a very wide and diverse professionals who are within the maritime industry coming in, and not also forgetting from the Kenya National Examination Council, who are responsible for assessing maritime causes. I would also like to mention the presence of Mr. Samuel Mambura, who is in charge of that docket, and not forgetting also Mrs. Tumaini Namoya. So as we come towards the end of this webinar, I have seen that in the chats, there are still questions coming. We have now reached to 7 unanswered ones. And I believe we can hold another webinar, which will address the inland waters, as rightfully said by our moderator. And we'll also wish to invite back Commodore Srikant to also give us some practice of compliance. And Advocate Njoki to be back here with now the legal jargons and the very many legal terms Thank you very much, ladies and gentlemen. And up to here, I would wish to now conclude this webinar, and watch out for the next webinars that are coming up, especially the single window, the maritime single window. We are having the webinar in the next 2 weeks, and it is a very important webinar to attend, especially for shippers, shipping agents, exporters, importers, as the maritime single window system is entering into force in January 2024. So, and also for our students who are taking maritime courses, this is a very important webinar for you to attend. The webinar will be presented. The presentation will be done by Ms. Mwanaulu Isa, who is a Director of Trade Facilitation at the Intergovernmental Standing Committee on Shipping, and she was the head of project for the Kenya Maritime Single Window implementation, and therefore her wide experience would benefit us all in terms of understanding what is this single maritime window system that is coming into force in January 2024. So, ladies and gentlemen, thank you very much, and see you again in another webinar.
Thank you.
Thank you.